Αγαπητοί συνάδελφοι, γεια σας. Καλώς ήρθατε και στην πέμπτη διάλεξη του τρίτου κύκλου διαλέξεων που διοργανώνει η Ελληνική Ένωση Διαμεσολαβητών σε συνεργασία με τον OPEMED. Σας ευχαριστούμε που είστε πιστοί και παρακολουθείτε τις διαλέξεις μας, τις οποίες ετοιμάζουμε με μεγάλη επιμέλεια. Εν πρώτης, πριν ξεκινήσουμε, να ζητήσω συγγνώμη για την μικρή καθυστέρηση, η οποία οφείλεται σε τεχνικούς λόγους που είχα εγώ. Λοιπόν, κατόπιν τούτου, ελπίζω να με συγχωρέσετε, θέλω να ευχαριστήσω τον κύριο Μπρούνι. Alessandro, I wish to thank you once again for having accepted my invitation to be here with us today and to make a presentation which is based on your big experience about especially the reaction of lawyers in Italy, which was, of course, something very interesting in 2012 and which ended in 2013 in the promulgation of a new law. I can tell you that the day on which the law was promulgated, it was September the 20th of 2013. I remember because we were in Paris at the Congress of the International Academy of Mediation, and one good friend, a lady, Italian, announced that the new law was there, and she explained why the precedent one had been cancelled, which, as a matter of fact, if understood correct, was not a cancellation, but it was put aside because it was considered to have gone beyond the authority of the executive power to promulgate such a presidential decree. So the new law you have promulgated have inspired us, and it is the Italian model, as we call it, and we have followed it. But I think that still we have changed. I will tell you later, not to take your time now. Alessandro, will you allow me to present you in Greek?
Yes.
Thank you.
Welcome.
Λοιπόν, ο κύριος Μπρούνι είναι δικηγόρος από το 1996, είναι και διαμεσολαβητής, διαιτητής, αναγνωρισμένος από τον Διεθνή Κατάλογο Δικηγόρων, το Διεθνές Ευρετήριο Δικηγόρων, για το οποίο σας έχω μιλήσει, που λέγεται Who is Who για νομικούς, ως ένας από τους λίγους κορυφαίους δικηγόρους στην διαμεσολάβηση ανά τον κόσμο. Ο κύριος Μπρούνι είναι ιδρυτής της Κονσίλια. Δεν ξέρω αν έχετε ακούσει ποτέ για την Κονσίλια. Είναι ένας Ιταλικός σπουδαίος πάροχος υπηρεσιών εναλλακτικής επίλυσης διαφορών, που ιδρύθηκε από τον κύριο Μπρούνι μεταξύ άλλων το 1999, και ο κύριος Μπρούνι έχει διεξάγει περισσότερες από 5.000 διαμεσολαβήσεις σε όλους τους τομείς, ιδίως σε διαφορές εμπορικές, κλιματικές. Ορίστε. Σχετικά με τις καλές τέχνες, τον αθλητισμό, διαφορές καταναλωτικές, ιατρικής ευθύνης και πνευματικής ιδιοκτησίας, καθώς και πολυάριθμες περίπλοκες διαφορές συμπεριλαμβανομένων διαφορών με αντικείμενο πολλών εκατομμυρίων και πολυμερών διαφορών. Alex, when I said that you are very close to Jeff, I was right. He has done 1,000 mediations, but you have done 5,000. So when you will reach his age, you will have done more than 6,000. Ο κύριος Μπρούνι είναι ειδήμων σε αθλητικές διαμεσολαβήσεις, κάτι που ενδιαφέρει το Σέργιο ιδιαίτερα, ο οποίος ασχολείται με την αθλητική διαμεσολάβηση. Και για τις καλές τέχνες είναι ειδήμων. Αυτό δεν το ήξερα, το έμαθα τώρα, με την ευκαιρία της διάλεξης, παρόλο που τον γνωρίζω πάρα πολλές δεκαετίες. Είναι διαπιστευμένος από το Διαιτητικό Αθλητικό Δικαστήριο με έδρα στην Λοζάνη Ελβετίας και το Διαιτητικό Δικαστήριο Καλών Τεχνών. I did not know your competence about arts, Alessandro. Indeed, it's the first time I have been advised of that based on your bio. Με έδρα στο Ρότερνταμ κάτω χωρών, λοιπόν, το Διαιτητικό Δικαστήριο Καλών Τεχνών. Επίσης, είναι μέλος πάνελ, διαφόρων διεθνών πάνελ της Αμερικανικής Ένωσης Διαιτησίας και του Διεθνούς Κέντρου Επίλυσης Διαφορών και διαμεσολαβητής της Ασιατικής Τράπεζας Ανάπτυξης. Είναι διαμεσολαβητής πιστοποιημένος από το IMI και ο πρώτος Ιταλός πιστοποιημένος από το IMI ειδήμων στην δικηγορία διαμεσολάβησης. Είναι επίσης διακεκριμένος τέλεχος της Διεθνούς Ακαδημίας Διαμεσολαβητών και μέλος του Chartered Institute of Arbitrators του Λονδίνου. Η θεματική της διάλεξης του σήμερα είναι πώς να χειριζόμαστε τους δικηγόρους στη διαμεσολάβηση. Εμπειρίες από την Ιταλική οπτική γωνία. Πιστεύω ότι το θέμα μας ενδιαφέρει όλους πάρα πολύ λόγω των δυσκολιών που συναντάμε στην διεξαγωγή κυρίως των ΙΑΣ από την αντιμετώπιση διαφόρων αρκετά μεγάλου ποσοστού συναδέλφων δικηγόρων. Alex, I said that the topic you will develop today is very interesting for us because actually we are faced with many difficulties in conducting mediations and especially in conducting the first mandatory meeting of mediation due to the attitude of lawyers, unfortunately. But between us, we can say this all the more that it is the same in Italy. So once again, thank you very much, and the floor is yours now.
Okay. Maybe we are sharing the same problems, so I'm happy to stay here with all of you. And thanks, Katerina, for this invitation, and thanks everybody for being here online for the speech of today. I feel really privileged and happy to be here with you to talk about the Italian experience, and I hope to contribute, even if only minimally, naturally, because of the time, through the cause of the spread of mediation in your country, as I have done with mine. Just good memories before, because with Katerina, we know each other for many years. And we met in the past at one of the UIA forum of mediation centers, and the forum organized every year or so by the Dispute Resolution Commission of the Unione Internazionale des Avvocati, all around the world. And after this, we had some other moments of professional growth and professional meetings together. I don't remember when and where, but around the world, for sure.
Indeed. Good. Yes.
Okay. So, Katerina, I don't want to steal your benevolence, but I really like Greece. And I spent the last 20 years or so each year during summer holidays in a different Greek location, so in a different location on Greek islands. So I'm also passionate of Greek ancient art and history. I'm very happy to stay here with you and your colleagues. And when I received the invitation of you, Katerina, sorry?
Have you ever visited Pelion?
No, not yet. Sorry, the unit. Okay.
Yes, I suspected it.
Yeah.
But you came 20 times at least every year.
But I like.
And it is time for you to visit Pelion, so I will be glad to invite you in my country house in a village in the Mount Pelion. I'm sure you will like it. Pelion, not my house necessarily.
Okay, I will keep in mind. Thank you so much. So, during my brief speech of today, I will touch the argument, as you, Katerina, said to the audience, on how to manage lawyers in mediation, the Italian experience, my personal experience, and the experience of Concilia and of the other ADR providers all around it. So I will speak about my personal experience mixed by the experience of Concilia. So I will not to say to you, this is my experience or this is the experience of the other colleagues of Concilia, but I will do a unique speech about it. This argument on how to manage lawyers in mediation is really near my knowledge because I'm a lawyer, first of all. And secondary, because I'm a professional mediator, I'm a mediators trainer, and I'm a founding partner, as you said before, of one of the oldest ADR provider here in Italy, Concilia. So during the last about 26 years or so, I tried to convince first of all myself, and then the other Italian colleagues, that mediation is really worthwhile upon many aspects, for time, in order to save time, respect to a judicial proceeding, respect to the judicial environment, for money, for the same reason, as you know, because the decision is in the hands of the clients and their respective lawyers, instead of to be judged by a third party, the judge. Because of confidentiality, simplicity, we can say because of informality of the procedure, and because there are many other aspects that we have no time to speak about, but I know that you know as a mediators. These are, as you know, only some principal columns of the mediation procedure, and these points and these advantages have to be known by lawyers in order to convince them to try to mediate cases of their clients instead of going before a tribunal. So for this reason, we will address two main topics in this brief lecture. How to manage lawyers for mediation. So how to convince our colleagues to try the procedure, especially when they are reluctant and when they don't really know the power and the magic within. And the second point will be how to manage lawyers in mediation. So after they have decided to try to mediate a case and they, with their respective clients, have entered a mediation room, how to manage them in favor of the procedure and in favor of a conciliative possible agreement. But before doing this, a brief Italian legislative introduction is needed. So thanks, Caterina, to have introduced the Italian law, but I don't know if some of you, apart from Caterina, knows our legislation regarding mediation in civil matters. But as some of you may know, the last Italian law on civil and commercial mediation, the legislative decree number 28 of 2010, prescribes as mandatory the presence of lawyers near their clients during mediations. In this way, lawyers have to participate near their clients in any kind of mediation related to civil and commercial issues. From the very beginning of the proceeding, so the moment of the deposit of the mediation requests, to the very end of it, until the signing of the possible mediation agreement has done. And a question arises. If lawyers are absent, what happens? The mediation agreement will not have the power of enforceability in itself and has to be proposed for the enforceability by the party who wants this enforceability in itself, where before the president of the tribunal, where the territorial judicial competence has to be rooted. Even if 12 years ago, so at the very beginning of the law in Italy on mediation, and for quite many, I used to say many years on, lawyers were reluctant to assist clients in mediations. Nowadays, the situation has, I can say that has completely changed in favor of a more conscious and a more aware choice to try the institute by lawyers as well as their clients for a series of reasons that I would like to summarize in bullet points with you. The first of all is that lawyers are practically obliged to do a mediation attempt, because if they do not try to mediate a case, they cannot start a judicial proceeding. This situation occurs in the cases provided by law by the legislative degree I said before, where a mediation attempt is mandatory. Which are these cases? Inheritance, division of assets, real rights, family pacts, loan, real estate, lease and company lease, condominium cases, compensation of damages resulting from medical and paramedical malpractices, or resulting by defamation, by the press, or by any other means of communications. And last but not least, in cases of conflicts upon insurance, banking, and financial cases. In fact, if we see this, if the deposit a judicial case in a conflict where the law prescribed the preliminary mandatory attempt of mediation that they have not pushed, so they have not done, practically now in all these cases, the judge in Italy sends the parties back to a mediation attempt, ordering the payment of some expenses to the party who didn't deposit a preliminary mediation request, or to the party who was absent at the preliminary meeting. As second point, lawyers are favored by the Italian bar tariffs. In fact, where a mediation ends with an agreement, with a conciliative agreement, we say conciliation, conciliazione, their honorary may be higher. For some years now, a sort of success fees have been planned, and they can earn more money if the agreement is found. So they are happy to, to go into a mediation to try to solve, because they may earn more money. For third, they have learned, lawyers in Italy have learned that assisting their clients in mediation, naturally when it is mandatory, or when mediation can fit for a case. So we have not a magic wand for all. It is not one size fits all, naturally. But when it is possible, assist clients in mediation, it is better for them for many aspects. And it is not a sort of loss of power, as in the past my colleagues believed by pushing a mediation attempt. For the fourth point, they also have experienced that an happy client after a mediation procedure can potentially, but also practically, I used to say, be a strategic asset for a lawyer, because he is acting for him as a certain sort of sounding board or a megaphone in order to make advertising on mediation and on the work of that lawyer. Over the last year, I used to say over the last 15 years or so, we as Concilia have served many lawyers convinced about the magic and the positive power of mediation, who continue to fill mediation cases with us. Practically, I used to say every week. And they have told us that over the years, they have seen their clientele grow. So the number of clients growth per year, precisely because satisfied clients in mediation have done themselves good publicity of their work. But, dear Katrina, before reaching the result of today, we have here in Italy today, where lawyers are more friends of mediation than in the past, we had, as you said before, many problems with them. In fact, I used to remember that initially they didn't recognize mediation as a real important tool of dispute resolution at all, and they greatly opposed it. We in Italy arrived at the point when the Constitutional Court declared the unconstitutionality of the mandatory attempt of mediation on certain matters. And the article which provides for it within the law, within the legislative decree number 28 2010, I said before, the article 5.1 was repealed as unconstitutional because it was deemed against the law. Fortunately, after that black moment, the article in object was, after some years, was reinserted as Article 5.1 bis within the law that is in force now. That is the same of 2010 with some, novelties. And the mandatory attempt on mediation was practically restored, fortunately, and we have this now. This is why I mediated a lot of controversies during these last years, Katerina, because it's mandatory, and because the Italian way of doing mediation has changed. Italian law, as you may know, is characterized by the so-called opting out solution, where for some kind of controversies, we said before this kind of controversies, condominium, banking, financial, real rights, loan, and blah, 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 it is prescribed by law a mandatory attempt on mediation, which the parties are not able to avoid. Because if they do like that, they can be obliged to pay judicial expenses, as I said before, and to come back to mediation. But on the other hand, even if a mandatory attempt is prescribed by law, and this is the opting out, because they can exit from the procedure after only a first preliminary meeting, when there are some objective reasons which do not permit them to stay in mediation. Let's make some examples. Maybe the right of the claimant is prescribed, so it's a nonsense to stay in a mediation procedure, or the party has not to do with that controversy, so why she or he has to be there, etc. So this is the opting out, so the possibility to exit. And this kind of solution has been used by many other countries, as Katerina said before, especially the eastern countries of Europe. When lawyers started to understand that mediation can be useful because can solve controversies that differently can remain with the tribunal for years and years and years. And when they do understood that accompanying their clients in mediation has a significance of appearing for their clients as we can say their saviors. And when this could make the difference between not to be paid in tribunal, and even if paid less, to be paid and to be thanked in mediation for having resolved their problems, increasing the esteem their clients have of them. After all of this, they become supporters of mediation here in Italy. So before to deal with the 2 points I said before, I would like to speak about with you, let me talk briefly about some considerations I have made during the years in order to try to put lawyers in the real right place, giving them the right consideration in mediation and for mediation. So in and for. Quite 20 years ago, I wrote one of my best sold manuals on mediation called "To Mediate is Worthwhile." And I asked to one of my best US friends, that is a well-known mediator, and I know that you know him because he held for you a speech in the past. I'm speaking about Jeffrey Abrams. Jeff Abrams was asked by me to write the introduction of my book. And in this introduction, I asked to him to explain how mediation has spread over his country in the past, rendering nowadays Texas one of the major US states in favor of mediation procedures. And he explained to the readers of my book, to me too, first to me and then to them, that great work was done directly. Sorry, is there some audio? Okay, I can continue. I'm saying that he explained this, and he explained that a lot of great work was done in the direction of lawyers in terms of their acquaintance with mediation, and in terms of advantages also for them guaranteed by the mediation procedure. In a few words, if we as a lawyer, or if we as mediators, or if we as lawyers and mediators, or if we as ADR provider managers, if we can be able to shorten the distance among lawyers and mediations, the situation may radically change, naturally in positive. So what I mean that we will have more mediation requests, we will have more mediation initiated, and we will have more negotiation, which brings to efforts. This was also the Italian route for the transformation of the mentality of lawyers and the approach of them and their loyalty to mediation. And the route is not finished right now, and the transformation is still in progress here in Italy, as in other countries who adopted the opting-out solutions. So that said, how to do for a better understanding by the lawyers, but also by judges, and in general by the public, by the crowd, by people, of the matter of mediation. So how to deal with them? We as mediators are not politicians, we know this, and we can imagine actions that brings some goals in mediation. But it is obvious that in every jurisdiction, without a base of laws in favor of mediation, we are nothing, because the route is very difficult. Even if we can do strong and we can do good efforts to the cause of mediation. So we do need to have a base of law in favor of this incredibly magical instrument that is called mediation. Till now, the Italian experience is that the Italian law doesn't provide advantages for lawyers at all. So lawyers who use mediation, are cut out. But in the future, legislation, I hope for this, could be different and could take in consideration some benefits for lawyers in mediation. For instance, one of these benefits could be the possibility to assist clients in legal aid regime, and the possibility for that lawyer who assists the party to be able to obtain his fees directly from the state, from the government, as he can do now during the process. We don't have still now this in Italy, but maybe in the future it will be like that. I can say that it's necessary to remember that we are living in Greece, in Italy, but we are working in civil law countries, where the idea of a tribunal justice is really strong and rooted still now. But we know this, that it is possible to create additional value, addressing people to try mediation and tempting lawyers. We need to tempt lawyers to try mediation more than they have maybe tried before. So how to tempt lawyers? During the years, we in Italy did some actions that you may duplicate in your country, in Greece, or you have done this yet. For lawyers, for example, we as Concilia, but many other ADR providers all around Italy, we have tried to reduce the tariffs for certain periods and for certain kind of controversies. This was in order to attract as many mediations requests as possible. And believe me, this tool was very great because fewer costs for clients may significate more fees for lawyers accompanying them in a mediation procedure. This was one of our tricks to improve the number of mediation deposits in every area provider here in Italy. Secondly, we started to create moments of better understanding of the procedure. For instance, by organizing seminars, workshops, short moment of confrontation among lawyers, and helping them to express their feelings toward mediation and other related fears on mediation. But the route was not complete because we needed to advertise about the power of mediation, judges too. So what we did for judges during these last years, routinely, we organized seminars. And when I say we as Concilia, and we as the other area providers, we as associations, we as blah, blah, blah. Okay, so the area movement here in Italy. We organized seminars within tribunals for judges. Also, with the help of some institutional bodies, as for instance, GEM. Caterina, you know GEM. GEM is the European Group of Magistrates for Mediation. That is a French association that is spread all over Europe and has its own country section. We have one in Italy. You have one in Greece?
Yes, indeed.
In fact, so this was like a steroid for our career as a mediators. What we did for the population, for the quisque de populo, as we said in Latin, we did advertising, and still now advertising is frequently made on newspapers, television, radio, other kinds of information, or we did other kind of advertising, as for example, within shopping centers or within supermarkets. You know, to bring flyers about mediation. Hey, listen, Mr. Mary, you want to know how to deal with your problem? Now you can choose mediation. Well, what does this means? Does it mean that you can stop to go to tribunal? You have another way, more facile, more less complicated, and more cost and time saving. Wow, can you advise about it? And we say yes. So we used to take door to door this information. And it was great for us in all over Italy. Now, passing to the second point. So how to manage lawyers in mediation. We need to try to speak a common language, trying to have the same starting points among us, among all of us, all this distinguished audience. First of all, no doubt that mediation can be greatly effective if lawyers who assist the parties are well prepared to act as a mediation advocate with the art of assisting their clients in a mediation procedure. In fact, it's crucial, it's really very important that lawyers in mediation take a step back in favor of an awareness of their clients who, in mediation, they must have the total control of the situation. You know that mediation is done between litigants, not between the lawyers who assist them, as opposed to in a court where lawyers are often the only, we can say, trait d'union between their clients and the court. So to be really full of power, to be a really powerful tool for their clients, lawyers in mediation must recognize the litigants, helped by the mediator naturally, so helped by us, but must recognize the litigants as the soul who make possible an agreement that is based upon interests and needs. So the role of lawyers in mediation is different from the parties one. only these lasts can find a mutual and possible solution, as we know, while the first have the control of a situation in a juridical point of view. So they have to control that juridically the solution found is correct and not against the law. But they don't need to intrude or to substitute themselves to their clients in finding these conciliative solutions. So we need to teach them that this is the solution. They don't come, before their clients, they come after in mediation. The Italian experience about this is and was emblematic, where lawyers passed from a negative perspective, vision, to an active role in mediation procedure. It is really vital that the category of lawyers could be able to improve their skills and role in mediation. In Italy, we passed many years, we as Concilia, but we as the ADR movement in general, to train lawyers in mediation advocacy. That is the art of assisting clients in mediation instead of representing him before a judge, recognizing to the lawyers a real concrete role and impossible to do without it. As they understood the relevance of their presence in mediation, they started to include mediation assistance in their professional offers. And nowadays, many Italian lawyers, I used to say the majority of them, me included, write within their websites, within their business cards, letterheads, that they are offering assistance in mediation because they are expert in mediation advocacy. For instance, by my position, I am not only IMI certified mediator, and I advertise this to my clients, but I'm also IMI mediation advocate. So this second, this second recognition by the IMI, that is the major institute worldwide who recognize the quality of mediator, but also of a mediation advocate, I will probably, I will advertise for the future. And I'm advertising till now to my clients. They know, all my colleagues in Italy, or the majority of them, know that this offer can be really attractive for the future potential clientele and could duplicate or triplicate or quadruplicate their professional activities, so their business, because maybe per year the number of clients may duplicate. That said, we have no doubt that lawyers are practically the real clients of mediation and the real clients of a mediation provider as well. And because they are so important in a mediation procedure, they should be treated with white gloves, without being too cheesy from one side, but without even being too much hard with them from the other side. In fact, only if lawyers are deeply convinced that assisting their clients in a mediation procedure is better than to representing them in a court, that lawyer will deposit a mediation request and will be willing to try to solve the problem of his client and with his client in a mediation procedure. So the way you welcome lawyers in a mediation is also crucial. So go on, because we have no time to, to be more hard on this. There is an important study of psychology that says us that it is good to welcome lawyers with a smile mode. In fact, smile has a, we can say that a smile, or psychologists say that a smile has a formidable quality to relax nerves, making relationships easier. Those who smile give us a feeling of well-being, we know this. The body of those who receive a smile, on the other hand, relaxes and then lowers or eliminates competitive stress and stimulating collaboration and problem solving. So if you didn't try it during your mediation, please, you need to try. And maybe, Katrina, during the next lecture in the future, if you will invite me again, you will say me the results. And I'm sure they are positive for your career, for the career of your mediators. Professor Lieberg, that is a researcher of United States University, the Loma Linda University. In 1985, he said that those who smile develop the so-called gamma frequency that is in the brain and that produce waves that can concretely synchronize neuronal activity and support memory and problem-solving skills. So please smile. A smile we can consider a smile like an open door. We can say an open door to relationships and wellness. I'm sorry, but again, I cannot go deeply with these argumentations because we have no time. But in mediation, please smile. To lawyers first and there to their clients. You will have only positive effects. Secondly, after a good smile, it's important the use of humor during a mediation because it's fundamental, especially when a mediator wants to relieving the burden of reality, that is the negative conflict for the parties and their lawyers. For example, a humorous joke, naturally, when and if it is possible, it can release tension of that difficult situation that is a conflict, making everything lighter and more sustainable. We can say that it's like a social facilitator and can create alliance between the mediator from one side and the parties' lawyers from the other side. So again, please, if you can, use also humor in your mediations and you will feel the differences between after and before. Now, I would like to see with you how to manage lawyers during a mediation procedure. So during the procedure in itself. First of all, here in Italy, experience teaches us that when in a mediation procedure are present lawyers who act against the mediation or who are, however, not in favor of the institute and are only there to comply with the dictates of a law, for instance, of the Italian law, it is better and preferable to start mediation proceeding with a caucus, only with them. So with a private reunion, only with them. Not immediately involving their clients, which is preferable that they remain outside the mediation room for a while, for 5 minutes, 10 minutes, the time it occurs. So with one excuse or another excuse, the choose is up to you, but a mediator may invite the lawyers to attend a brief meeting only with the mediator, just to manage some, and this is the possible excuse for the parties, just to manage some exclusive legal topic that may annoy the parties or may be not of interest for them. Therefore, our decision as mediators to have a first caucus with only the lawyers may find a justification for the parties that way. So remember, you can say to the party that you have to stay for 5 minutes or for 10 minutes with only the lawyers, just to, analyze some juridical points that can be annoying for the parties. So it's better than that they remain outside the room and blah, blah, blah. Okay, just to have them with you and the parties outside the room. It's very important. In fact, during this first caucus with only the lawyers, you can be frank with parties' lawyers, going with them to the core point that you want to say or you want to remember them. What is this point? is how they are asked to stay in that mediation procedure. Naturally, before doing it, we have to thank them. Remember, the first thing to do is to thank them for being here with you, mediator, and for have chosen this way of dispute resolution for the clients. It makes the difference. I used to thank, just an example from my side, from my experience. I used to thank them in this way. Listen, Mr. Lawyers, thank you for being here. And thank you very much for the time you are spending and you are dedicating to me. Could you imagine their reactions? We as a lawyer knows that we are generally habituated to treat with judges. So is it possible to imagine that during a process in a tribunal, a judge can say such a similar phrase to lawyers? I want to know from the lawyers present today in this virtual room, has it happened to you? Personally, as a lawyer, I have never been treated this way from a judge, by a judge. So remember, thank you for the time you are dedicating to me. It is an incredibly powerful phrase to use in every mediation at the very starting point. Further, I used to, I can say, I used to fight against their reluctance for mediation with another little trick, psychological trick. I tried to increase their egos because, you know, as a lawyer or who are lawyer in this room knows this, that every lawyer is characterized by a huge ego. And we know this. So I used to increase their egos, telling them that I do need them during all the procedure and representing them that I will ask for their help, for their support, for their juridical and professional experience whenever I need it. I can say a phrase like this. I would like to use your professionalism if you will permit it to me. In the case of I need explanations by you, or in the case I need to know more and better about this controversy. Does it sound good for you, Mr. Lawyers? The sense of this speech that I say to them is in order to have them from my side, from the side of mediation, and not having them contrary to me and contrary to the procedure. And I can continue to say to them, in fact, thank you for this, because even if I was chosen by the mediation provider, also for my experience in this particular field of controversy, I can imagine, and I am sure, that you are more focused on that controversy and more prepared than me. Also, because you are managing that issue, surely for much longer than me, with your clients. That said, you cannot imagine the reactions they usually give to me. I'm trying to summarize these reactions because we can say that with a little disbelief for what I say to them, they start to have another point of view of me as a mediator and of the mediation procedure. And they used to give me their availability to be consulted whenever I would like to do it, because I will need them. So that said, this is this can be considered the we can say the first important point of contact between the lawyers, them, and me as a mediator. And every lawyer who struggles to understand the power of mediation and therefore opposes to it, when he is treated in this way, corroborating his position and asking him for help in case of need, starts to be more flexible and less combative, and usually open his doors to communications and dialogues with the mediator. This is for sure, believe me. And I know that you know this. So act that way with your lawyers in mediation. You will have good results after having prepared and having welcomed them this way. We can say that they are ready for the truth. And which is the truth? The truth is that they are not as important as their clients in mediation, because their clients are the main actors, the main negotiators, and the main peacemakers of the disputes. Sometimes I used to speak with the lawyers also about the tariffs, okay, they can charge for the assistance of their clients in a mediation procedure. And I represent them that it could be possible, comparing many factors as less time involved, potentially less responsibility, and potentially less stress for them. It is possible that these tariffs are higher than the ones they can charge for representing clients before a judge in a court. So they are so happy when they know this, or when I remember this to them. And finally, I used to help them to understand some differences between their role of assistant of the client in mediation and the one whom they have of representing client in a court procedure, because you know that is completely different. From one side you have the assistance, from the other side you have the representation. And when they understand that their role is less complicated, or potentially less complicated, and potentially they are less responsible because they have less responsibilities in mediation, they say, wow, is it true? And they usually choose to enter the procedure and to remain at the negotiation table until the end, whatever will be the solution. Now, we will briefly pass to speak about how to manage lawyers during mediation once it has started. So in a very crucial moment, regarding the Italian experience and regarding the experience of Concilia, a mediator need to supervise and control activities of lawyers in mediation from the beginning to the end of the procedure. Why this? Because every lawyer tends to want to direct the procedure. It is in our DNA as lawyers. You know this because you are lawyers too, or who his lawyer know this, because we feel we need to control and to direct everything of the procedure, every passages of mediation, every stage of it. Of course, for the sake of our clients, but we act like that. But in this way, it's really possible that a solution may not arise, because lawyers are not the parties, and they cannot approach negotiation in terms of interests and needs, as instead can and must do the litigants, their clients. So, when a mediator feels that the lawyers or one of them are particularly, we say, directive, because they want to control any aspect of mediation and any behavior of their clients, maybe it's preferable to have them seated near the mediator and the clients seated farther away. While instead, on the contrary, if we have found lawyers malleables and lawyers who know the procedure of mediation, maybe it is better having the parties seated near the mediator and the lawyers farther away. So the contrary, I said before. We as mediator must pay a concrete attention to teach lawyers in which way it is preferable to prefer to the other party. In fact, usually in criminal, you know this, lawyers are prepared to communicate with colleagues, not directly with counterparty. Also because this is not permitted. For instance, for the Italian law, it's not permitted. In mediation, on the contrary, it is better the lawyer discuss directly with whom may do the difference, agreeing with his client. So the counterparty. Another important moment of growth to manage lawyers could be during caucusing with the party and his lawyer. Can I continue? I'm sorry because, okay. We can say that it is not ordinary that a lawyer had prepared well the procedure in his office with his client before the starting of the mediation. So for this reason, we need to recreate that moment during a caucus. Without making the lawyer lose face, we have to analyze the problem with his client in terms of priority to be solved. In fact, both the lawyer and his client have to, understand that a mediation proceeding and a mediator is not a sort of magic wand. I said before this, because we are not magicians. We cannot solve any human problems. That said, we need to cooperate with the litigants and their lawyers to make order to the many requests, often dictated by a sort of whims or by, litigation, helping them to save only the requests that could be potentially acceptable by the counterparty. Naturally, the same we will do in the second caucus with the other party. I have some voices that comes on my ear. Okay, let me check. Perfect. I'm sorry, but okay. I want you to remember when in the past, during your training courses, you have learned about BATNA or WATNA or ZOPA. Do you remember the best alternative to a negotiated agreement or the worst alternative to a negotiated agreement and the zone of possible accord? We were habituated to think about this research must be done together by the mediator with the parties and their lawyers. But naturally, if an alternative is best or is worst, this has to be said only by the party, not by his lawyer, who is there not to replace his client naturally, but is there to protect him during all the procedure, to assist him. So we need to teach the lawyer to stay at his place. Without, I said before, without to be too much hard with him. For to help the lawyers to stay well in mediation, we need to speak with the lawyers in a legal way, because we as lawyers are habituated to speak that way in tribunal with colleagues, with judges, with paralegal. So it's in our professional nature. Again, it's in our DNA speaking legal language. But we need to say them to let their clients express in an interest and needs-oriented language. So doing this, the mediator will speak two different languages. The one with the party, so the interests and needs-oriented language, and the other with the parties' lawyers, so the juridical language. Only in this way we can help the lawyer to feel himself as important and necessary as he is in any mediation. Because if we try to ignore him, or worse, if we try to talk to him with a language that he, as lawyer, can't speak, a language of interests. What are his interests? What are? So there is a risk that he will miss him. We can miss him. And if we miss him, we miss the party. Because if we will put him against us and against the procedure, the party will be against us and against the procedure. And we don't want this at all. So it is clear that a mediator could start, if possible, naturally, to speak with the party. And I know that you know this. Asking to the party to speak about the situation and the conflict, and asking to the lawyer to be patient and to wait before he could speak about the problem. But after the speech of the party, please take time to speak with a lawyer, because a mediator could ask to the lawyer, for instance, to, I don't know, to complete the explanation with some more particular, or can ask to enlarge the cake, or to consider some juridical aspects or some juridical points. Even if I know that you know that it is preferable that a mediator, especially in the very first phase of mediation, would not address certain juridical aspects, because it's not so good. In a few words, we can say that a mediator does not have to ignore the presence of lawyers, but on the contrary, must not keep the lawyers at the center of the negotiation process, relegating parties to B factors. Because if we did like that, maybe it would be a danger for the entire mediation procedure, because the lawyer, could, could go away, and we could lose the parties and the possibility of a conciliative agreement based upon interests and needs. That is our main goal as mediator. In Italy, we started to have many mediation requests when lawyers understood that their role in mediation was active and proactive, not passive or mere necessity. We have experimented in Italy that a good work can be done with lawyers when the mediator creates a relationship of trust with them. If a lawyer will trust a mediator, he will be more in favor of mediation procedure. Many mediators, and me as a teacher, as a trainer of mediators, and during examinations in the Italian Chambers of Commerce, I found in the past more than now, but now it's still in progress, that sometimes many mediators have an arrogant approach with lawyers, trying to stop them at every stage of mediation and trying to teach them how to do in front of their clients. This is not good at all, because in that way it can be possible that the lawyer feels like to lose face close to his client, and it is not good at all. So any reproach you have to do, and you have to express to a lawyer during the mediation, you have to be, it has to be made not in front of his client, but in a separate way, maybe in a caucus, only with him, lawyer. So when a lawyer perceives that you didn't make him lose the face, he may establish with you, mediator, a steel pact, a very strong steel pact, and he starts to trust the mediator and to trust the procedure more than in the starting point. On the contrary, if a mediator places himself in a certain sort of, we say, war mode, war is a word unfortunately used nowadays, against the lawyer. So it can be possible that the lawyer who dominates upon his client, we need to remember this. We as lawyers, we know this, but we as mediators has to know this at the same time, because the lawyers dominate upon their clients, also in the mediation procedure. So when this is possible, also in mediation procedure, it is possible that, you know, if you are arrogant with that lawyer, he can leave the stage and leave the procedure together with his client. So what happens after? Game over. Mediation is finished. And who is the main responsible of this failure? You, the mediator. So lawyers must be put in the right place in mediation, as the right place is close to his clients, yes, but after the client, not in a different place. So they are not secondary to anybody, because if the clients, the parties of mediation, wanted to do without lawyer, simply would not have brought them to the procedure. So if lawyers are there, they have significance for the parties who represents or who assists. The lawyer of a mediation advocate differs very much substantially from that of litigation advocate. So a transition, even in your country, in every country, a transition is required from a zealous advocate to a settlement or a solution advocate. So sometimes this transition, as in Italy, is really difficult. It was really difficult in Italy for a litigator, habituated to litigate all the time in tribunal for his client. Personally, when I meet a lawyer acting in mediation as a litigator and wanting to litigate instead of to negotiate for his and with his client, I look him in the eye and I tell him to believe me and to believe in my professionalism and the mediation procedure. I say a phrase, a similar phrase like this: listen, Mr. Brown, Lawyer Brown, I really hope you can believe me and trust me, because I will put into this mediation, as I do always, all my professionalism and all my experience. And you and your clients will be treated as I will do with the other party, at the very best of my possibilities. So this kind of speech have the power to move the situation from a psychological point of view, but also from a concrete point of view, and renders lawyers more close to me as a mediator and more close to the mediation procedure as well. Briefly, when a golden bridge has been created between the mediator and the lawyers of the parties, may also happen, and it happened in many mediations, to me, to my colleagues, or maybe to you too, that the lawyers start to support the vision of the mediator in trying to convince their clients of the goodness of mediation and the need to find an agreement, a conciliatory agreement, instead of, for instance, give up or come out the negotiation procedure. Maybe you found also this, because other times it can even happen, and I had this during some mediations I did, that when the lawyer is alone representing his client and his client is absent because he didn't want to stay in front of the other party, because he didn't want to participate for many reasons, blah, 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 it could be possible that lawyer ask to you as a mediator to directly explain the conditions of a possible found agreement with the counterparty that you have just tried, that you have just found with the counterparty to his client by having a phone call with him in his presence. So it's possible that a lawyer say to you this: please, Mr. Mediator, could you be so gentle to stay with me in order to contact my client and to explain directly you the situation? And this is fantastic, because it's a question of truth. you know, a question of respect. All these experiences I'm speaking with you are possible, naturally, but only if the mediator creates, as I said before, trust and a fertile soil where the lawyer can feel good and feels he is important and he is respected by the mediator. We need to respect him because he is here with us for you know, a positive function. I found no other solutions to try to convince lawyers about the, you know, the magical mediation. In other words, if we want that lawyers not oppose mediation, believe me, we need to make lawyers friends of the procedure, helping them to see, recognize their role, their responsibilities, their professionalities, and their time spent with us in that situation of mediation. I'm going to finish, but permit me to say something more. I remember a mediation where lawyers that in a first moment saw me and treated me as I was an alien or a failed lawyer completely changed their approach to me. The moment when I explained them their role in that mediation and my role, their responsibilities and my responsibilities, and when I thanked them for being close to their clients in this procedure and for dedicating time to me, from that moment on, I had their completely trust and their attention. And they were really important for me too, because, you know, they acted as natural bridges between me and their clients, especially when it was necessary to understand some difficult situations or passages for their clients. So they have me with them, and they have the entire process of agreement. Now, how to deal with lawyers when the agreement in itself has been orally made? So at the very final stage of mediation, the role of lawyers, as you know, becomes more important at that stage when it is necessary to write the official agreement, that in Italy we say the conciliative agreement, accordo di conciliazione. That moment is crucial because mediator has to leave the stage and the pen to lawyers. Remember this. Some mediators want to have power. I want to have the stage during this final stage, but it's not like that. You need to leave the stage to the lawyers because they are responsible together with their respective clients on what they wrote in the agreement, not you as a mediator. Your task has finished. You need to stay there to, you know, to react and to prove that they have done the agreement, but the agreement is from the parties and from their lawyers. So, for instance, according to the Italian law, the signing of lawyers render the agreement automatically enforceable, but they have to sign in order to certify all the clauses of that agreement, that clauses are not contrary to public order and to the mandatory rules of the legal system, the Italian legal system. At that stage of writing the mediation agreement, the most important role is the role of lawyers. Remember this, that have to be there with all their professionality as jurists to put black on white what their clients have negotiated before and agreed during all the procedure. So, as mediators, we need to remember this final moment, and that in this phase, it is very important and necessary that lawyers make their own part without pressing them and directing them. So, I think I have finished my presentation. I'm sorry for the short presentation, but I have covered all the points I wanted to cover with you today. So I hope all of you felt I was clear with you, because I spoke from the point of view of a mediator to you mediators. So hope you enjoyed my presentation, and thank you for your attention, and thank you again for inviting me to this distinguished, among you. Thank you so much.
Alessandro, thank you very, very much for this very instructive lecture you have presented to us, as we face exactly the same problems. I believe every mediator is faced with the same problems. And the advices you gave are, I'm sure, very important and very efficient, especially to smile. I fully agree with you that a smile can be precious.
Yeah. I
am of this opinion in all the aspects of our day-to-day life. So you have pointed out several aspects which are very interesting regarding mediation, especially compulsory mediation. And after our colleagues will put their questions, I'll take the liberty to put some also myself. Thank you again.
Thank you again, and I hope to be able to, to answer.
Oh yes, for sure. You will be. Σέργεϊ, υπάρχουν ερωτήσεις?
Όχι, δεν βλέπω εδώ. Ούτε στο Facebook. Αν θέλει κάποιος κάποια ερώτηση.
Thank you, Mary.
You were crystal clear, so everybody understood everything.
Maybe it's too late.
No, it's only 8 o'clock.
But you have your souls to be cooked, so.
So if there are no questions.
Η κυρία Μαλεβίτη έχει σηκώσει το χέρι.
Γεια σας.
Γεια σας, κυρία Μαλεβίτη.
Γεια σας.
Ελπίζω
να κάνω την ερώτηση και να τη μεταφέρετε ή απευθείας.
Απευθείας αγγλικά, άμα σας βολεύει.
Αν κάνω καλή χρήση, αν δεν κάνω θα το μαζέψουμε. I wanted to ask, what is possible for us to do when lawyers start to contact straight to one another and exchange proposals and points of agreement, and we don't even know that they are doing that.
So you are acting when they are acting by their own, without involving you as a mediator.
Yes.
The process, but this is positive, because if they reach a point of understanding, a point of contact, you need to stress positively this, saying them, I'm really happy that you are here, that you are trying to solve the problem of your clients in this way. So if if I can put my professionality, but you are going well. So thank you. So you need to stress positively this. I think that is like a blessing for the entire.
Yes, but if you know that, because sometimes you don't even know that, and they start to say, or that, or we stop, and you don't even know, or you learn after they stopped the negotiation and said, we are out of it.
You need to go quickly in focusing in order to ask them for all the particulars of the story of their clients. And you need to ask, do you have some contact? Do you had in the past some contact with the other party, with your colleagues? And do you reach some point that you want to say to me? So don't fear to ask him or her about the possibility that in the past they had chosen a way to stay together and to cooperate together. I feel this like a blessing, as I said before, because if they do reach common points and you don't know this, I don't care as a mediator. The important is that they are using that, that route of communication among them, between them, sorry. And if this is like that, more or less, and after or before, it will be on the stage of the mediation table. So you will know this from one side to another. So I'm not worried about this. Also, I'm really happy if this happens.
Yeah, if it's for the resolution, yes, of course, everybody is happy.
If it's against the resolution, we do need conciliative parties. So if they don't want to go on a mediation procedure, be sure they don't go on. So we haven't as I said before, the magic wand. The unique thing we can do is to compare with them and their clients the route for a possible process and the route for a possible agreement in mediation. So to compare at the same stage, and to compare this, maybe one time some lawyers will say, listen, yes, it is better to go to negotiate. So you cannot do in a different way. Or now I think that it's not possible to do differently from that.
Thank you.
Thank you.
Άλλη ερώτηση? Κυρία Μαλεβίτη, ελπίζω να μην ενόχλησα προηγουμένως. Όχι εσάς. Γενικά. Ευχαριστώ για το μήνυμα πάντως. Το είδα μόλις τώρα, δεν πειράζει.
What a beautiful smile, Maddie.
Yes, I love the smile. It was the best I heard in this.
Yeah,
beautiful.
Smiling is like a virus. It's like a virus, So it has an incredible power.
Yes.
Yeah.
Thank you.
Can I say something?
Ναι, Βίκη, πες, ακούμε.
Okay. Well, thank you very much for all your enlightening speech. They've been all very helpful. And I agree very much with a smile. It's definitely a good weapon to talk with the people, with all the people, lawyers and the parties. The humor was a very good idea also, and also a very good tool to use. It happened to me sometimes that the lawyers use the obligatory first caucus, as we have it here in Greece, to start a new procedure, but behind mediation. They enjoy the bridges that we build as mediators, and after that they want to make a separate procedure behind the scenes, and of course out of mediation.
And not paying the mediation proceeding. So not paying the mediation proceeding.
No.
Okay.
No.
How to manage?
How to manage this, yes. And I suspect, one time I was fully suspected that one lawyer that he did that, it was for the money. He didn't want to pay for the mediation, but he wanted to go on with the negotiation procedure, but avoid the mediation. And I believe it was for the money.
It was for the money for sure.
Yeah.
Why it is?
That's not very easy to deal with.
Yeah, it is the same in Italy. In fact, during the first preliminary meeting, we are using to explain the role of mediator, the role of the parties and the party lawyers, and we used to ask frankly to the lawyers during the very first phase, are there any juridical and objective aspects which do not permit to enter the mediation procedure? Because if yes, please tell me. If don't so if you don't see any aspect or like this, you need to enter and you need to pay. So before starting to negotiate a case, you know, to answer to this question. But it is not so, you know, it's not like that. So they sit down and I say, okay, listen, is there any aspect? No, not like this. But in the speech, during this conversation, I need to know if there are some objective aspects which do not permit the entering in mediation. If yes, they need to declare them. And I write upon the mediation minutes. If they don't have, I say to them, listen, from this moment on, you will start the negotiation. So your clients had to pay, and you had to recognize this payment. And this payment is recognized by putting this phrase of the payment on the mediation, minutes. So if they don't want to start mediation procedure, I know by that initial activities, and I can stop, because it's not better, it's not good to work for free, naturally. So with very calm, with humor, with a smile, with our techniques, with all our psychological tools, we need to let them know that it is important that we know if they have the volunteer to start or not. If yes, okay. If not, bye-bye.
In order to communicate, as lawyers, as mediators, in order to communicate the mediation as not an alternative, but another way to resolve our differences, we try to be very kind and very polite, and of course very civilized. And sometimes, and we don't get into argue with disagreement. With our colleagues and everything. But of course, I have seen that the smile and the humor is really something that works. Yeah. And now I am very positive that I heard that also from you. That I continue to use it. Yes.
There is an Australian professor, I don't remember the name, who who is all over the world with his workshops, and he teach how to smile and the heart of smiling. So it's incredibly powerful. Really, after one session with him, you are continuing to smile all the day with your parents, colleagues, and neighbors, and it's incredibly powerful.
Yes, our work is to build bridges between the parties, and that works.
Yeah, sure.
Anyway, thank you.
Ms. Putz is got something to say.
Yes, I was thinking about a way to manage lawyers I learned in France. I started to go to contact them before the starting mediation, even to go to their cabinets, to their studio, and they are always delighted about it. They really appreciate. So in Italy, I tried sometimes to do that, making possible transparency, because I decided to send an email both to one party and then the other, asking for a meeting via Zoom or a call, I don't know, as they prefer. And then that too had good results. Then for the first meeting, it's always easier to start talking, and also lawyers are prepared about their role in mediation because we talked about it before. So do you think that in Italy that should be possible? Because at one time in a formation in Italy, I talked about it, and the professor told me, no, I don't think so. But I insist, because really I saw that it's working very well.
I think that it can be powerful and it can be workable, but you need to have the permission of your area provider, naturally, because as you may know, as you remember, in Italy it is prohibited to contact the parties before the mediation by the mediator. But if you have this permission, you can do it, and especially because psychologically, if you divide the two lawyers, is more facile, in practice, to have their their attention and to make their acquaintance in mediation. On the contrary, if they can manage a still pact without you, so together, the two lawyers without the mediator, you are not so powerful. So they use to contact them before can be relevant and can do the difference. So I agree that is possible and it is advisable, especially when you feel before the starting of mediation that they are against mediation, or they think that mediation is a losing of time, or because they think that it's better to go before to a judge because they want to earn much more money. So in all these potential situations, it is really powerful. So yes, I think that it's contrary to my colleague professor. You say don't say name, please, because it's not good. But I think that it's incredibly powerful to have the possibility to have a preliminary contact to them individually, naturally.
Okay, thank you.
Thank you.
Κάποια άλλη ερώτηση? Όχι, δεν βλέπω εδώ στο Facebook. Κατερίνα, δεν βλέπω κάποια άλλη ερώτηση.
Okay, then, if there are no other questions, I will take the liberty, Alex, to ask you to explain to us how the first mandatory meeting works in Italy, because you said that it is an opt-in, opt-out procedure.
Yeah.
Very clear, it is the same here in Greece. But I would like to understand, because you said that in some cases, for instance, if the claim of the claimant is time barred, there is no need to go into a mediation. Do you need that the parties and or their lawyers are free to decide whether they will start a mediation or not in the cases where it is mandatory?
No. In the case in which mediation is mandatory, so for that situations I said before, inheritance, division of assets, real rights, payment pacts, loan, etc., they have to try to mediate. So they are obliged to participate to this preliminary meeting. And in this preliminary meeting, they have to say to the mediators, to the mediator, if there are some objective situation that do not permit them to go on, and so to enter mediation. But if there aren't these objective situations, they are obliged to try to mediate and to enter the mediation proceeding. Naturally, we as mediators here in Italy, but I know that in Greece is, I think that is the same. We are not, we have not the power to insist and to order them to enter the mediation proceeding. So the only thing we can do, and we as Concilia do this many times, is to write on the within the mediation minutes that that party wanted to start mediation, and the other party said that for her or for him it is not possible. So we leave to the judge the decision on who is right and who is wrong. But we inserted that the positions of the parties into the mediation minute in order to make the judge more near on what has happened in mediation. Because if we had the power to order the parties to enter mediation, especially or in the sole cases of mandatory mediation, it would be naturally more powerful, but we have not this power. So we cannot push for this. But if they don't have reasons, objective, you need to know objective, not subjective. So if they say, I don't want to try because I think that mediation is not powerful for my situation, but if this situation is inserted in one of the matters of the article 5,1 bis, for which the law prescribes a mandatory mediation, they cannot say like that. So the only thing we can do during the first preliminary meeting as mediators is to write the reality of the facts. So it's to write that one party wanted to start and the other want not. This is and this creates many occasion of entering in a mediation, because when you write that Mr. Brown don't want to enter into a mediation attempt that is mandatory, even if there aren't objective reasons to don't enter, he said, and at this stage I prefer to enter, because if you write this, I want to enter, because I don't want to make bad figure in front of a judge, and I don't want the judge order me the payment of some sum of money, because as I said before, the Italian law provides for the payment of sum of money to the parties ordered by the judge, to the parties which didn't want to enter into a mediation procedure that is prescribed as a mandatory by law. Okay.
Thank you very much, Alex. It's very clear, but I would like to put a question further. If I understand correctly, in Italy, there is a first preliminary meeting during which you examine to what extent the parties wish to proceed to a full mediation, if I may call it like that. You explain possibly the principles of mediation, etc. And you said that the parties may say, no, I do not want to proceed, to go to full mediation.
Or to start, excuse me, Catherine, not to proceed. In Italy, you need to start, because the preliminary meeting is not yet a mediation procedure, it's before. So if you want to start a mediation procedure or not to start.
Okay, okay.
Sorry, that it's crucial.
No, it's very important for me to fully understand and to understand correctly. So, otherwise, if they do not have good reasons, they must enter the mediation.
Yes, but the reason are not to be good or bad. It has to be objective.
Objective.
And civil procedural. So
Yes.
in order to say, listen, the rights is prescribed. Do you remember the example I did before? If
Yes.
the right is prescribed, it's a nonsense to enter into a mediation proceeding. So I need to put into the mediation minutes that I don't want to enter because I have a concrete reason that is objective, is not subjective. The objective reason is 2 points, because the right is prescribed. So please, I don't want to enter. So even only if you have an objective reason not to enter in a mediation procedure, you can act not to enter. But if you don't want because you don't feel that mediation it fits for you, this is not a reason for not to enter in a mediation procedure where this procedure is considered as mandatory. So you have not the volunteer, okay? You cannot say yes or not. So the opting out solution is, made results, and it can be possible to use the opting out only if you have objective reason to exit from a mediation procedure. If you need to go and to enter.
This is a very important difference with Greek legislation, which provides the obligation to go to a preliminary mandatory meeting, during which the mediator explains the rules of the procedure, mainly the principles of mediation, etc. And when this meeting is over, the parties may or may not enter into mediation without giving any explanation, any reason for which they decide not to proceed, and without having any consequences.
Wow.
On the contrary, if they do not go to the first preliminary meeting, which is nothing between us, okay? We know, all of us, we know that lawyers, for instance, call and they say, how long will it last? 5 minutes, 10 minutes. So a first preliminary meeting where the parties are not in a position to say anything, to get anything from mediation, is, to my opinion, useless, especially as it evolves in practice nowadays.
Yeah.
So you have increased consequences if you do not go into the preliminary meeting. You have to pay a fine, etc. if the judge so decides, but mainly the case cannot be heard before the court.
Okay.
This is the only sanction which is important. Yeah. And this is why people go to the preliminary meeting when it is mandatory, but they do nothing. And this is why we have a very, very small percentage of cases where the people went into a mandatory preliminary meeting because they had to, but there was no mediation thereafter, which in fact should be the goal.
Sure.
And which, to my opinion, was the goal of the legislator.
Okay.
But as it is now, the opt-out solution is free. So now, what happens in Italy if there are no objective reasons not to go to mediation, not to enter the mediation, and people enter the mediation? 5 minutes later, after the mediation has started, they may get out.
Yeah.
They are free.
It can be possible. They are free naturally because they have the obligation to try to mediate, and they can say after 5 minutes, we haven't reached any point, so we want to go out. We want to go from a judge, but they need to pay. So when they started to initiate a mediation, when they enter the mediation, they remain, usually they remain there until possible end. That is not necessary a conciliation agreement, but they don't use to pay for 5 minutes, naturally. We started to have more deposit, or more, sorry, we started to have more entering into mediations when we started to write black on the white during a mediation into the mediation minutes that one party, without any reason, wanted to leave the stage, because that mediation minute we go to in front of a judge, and the judge, when read that a party without reasons wanted to start a mediation proceeding, he said, okay, listen, go back and pay, you pay some kind of amount of money, because I think that you are wrong. In fact, some tribunal decisions of the last years said and ordered that a mediator needs to put into the mediation minutes the party who wanted to go on and the party who wanted to stop. Because during the proceeding, the judicial proceeding, a judge with that writing, with that mediation minutes, has to decide, has the power to decide who was in wrong and who was in right, in order to make an ordering to come back to mediation in case of he think about this possibility. So we only need to write what happened within the mediation minutes. On the future, the judge may order the parties to come back. We cannot say, hey, listen, you need to go, you need to start, you need to enter. We cannot push the party to enter. We are only asked to write what happened among them, between them. And after the decision will be led to a judge. So they know this. And because they know this, they are willing to enter more and more than in the past. This was this was our trick, the trick we use to push the party to enter mediation more than in the past.
Yes, very clear. Thank you very much. This is the difference. Mm-hmm. This is now I understand why the number of mediations has increased so much after the new law of 2015 in Italy, and why it has not increased up to now, in spite of the fact that the new law promulgated in 2019 has improved the situation. Thank you very much, Alessandro.
It was a pleasure staying with all of you. Thank you so much for the invitation again, Katerina. Thank you. And if you want to have some other updates about Italian experience, I will be here with you again in a future meeting. So thanks for the time you have dedicating to me.
Very, very much for your time, the time you have dedicated to us. And I hope to see you in summer. Of course, we'll remain in touch as always.
Yes, sure, for sure. Thank you so much.
Again, and have a nice evening and all the best.
Ms. Maleviti wants to say something. She raised her hand.
Sorry, I raised my hand after we leave, but I wanted to understand, isn't it, this obligation, isn't it against the volunteer, the willing, against the will of to be forced, or it's a way not to be this, I don't know the λέξη εκουσίως exactly, but yes, isn't that against?
No, because there is a law that prescribes for it. So you know this before to have a litigation. You know that there is a law, or you may know as a lawyer that accompany your client's mediation. There is a law that prescribes for it, and it is mandatory. So it is not an obligation to make an agreement. So you are not obliged to conciliate. You are obliged to try to do it.
Try to conciliate.
Okay.
Yeah,
So,
but the European law is not exactly, I think, is not exactly the same with your country's law.
you are speaking about the directive on certain
Yes.
civil commercial mediation.
Yes.
I don't remember, the 22008, something like that.
Yes.
Yes, but if you remember, there is a second comma of that article who provides for voluntary mediation, which says that if a state member have another legislation more, more invasive that prescribe more, it can be possible. So remember the second comma of the article, blah, blah, I don't remember which is, but there is a second comma. And we applied as Italian law, so the Italian law applied this second comma, rendering mandatory only the attempt on mediation, not the conciliation, so not the result. You are free, as Katrina said before, you are free to enter and after 1 second to say, okay, bye-bye. Okay, but you are obliged to try. In that particular issues, I remembered before, that are prescribed in Article 5, sorry, comma 1 bis of the legislative decree.
Thank you.
Thank you.
Thank you again, Alessandro. All the best, and keep safe, please.
You too, you all too, please. And we hope that this terrible situation will finish in a while, but
yes. let's hope.
let's
hope that it will finish.
Let's hope and pray. Okay, thank you so much. Bye.
Bye-bye.